Hello, and welcome to Immigration Talk, a space where we hear from an expert on matters related to the immigration industry, law and policy, and practice. I'm Rosalie Venstall-Dinan, and joining me is RCIC Tiffany Osman-Chi. Welcome, Tiffany.
Thanks again for having me back, Rosalie.
It's always a pleasure. Tiffany, how might immigration practitioners use C10 work permits to address challenges with the LMIA process?
Well, for the past several years, practitioners have been experiencing a squeeze from all sides of the decision-making level. We've experienced massive changes to the temporary phone worker program with LMIAs, cuts to provincial nomination allocations, and what many of us believe to be an overcorrection to federal immigration levels. And as we all know, LMIAs for our employers are very expensive, they are very time consuming, they're highly scrutinized, and they're increasingly difficult to obtain, with many officers applying what seem to be arbitrary decisions and rules. So employers have to prove that no Canadian or permanent resident is available, recruitment efforts have to be genuine, the wages meet strict thresholds, and advertising conditions and requirements are becoming very difficult. And as we said, provincial nominations themselves are reduced. So many provinces like BC and Ontario are conducting very selective invitation rounds. And in particular in BC, we're seeing recent draws showing that invitations continue to be targeted towards high income earners or those with very high scores, or they just continue to focus on high economic impact candidates. And here's where you can help as practitioners. This means that the general public is not being invited. Many candidates are stuck in all of the pools, and traditional pathways are narrowing. So we look for alternatives, and people pivot. A good option that many think about is a significant benefit work permit under Section 205A of the regulations, and most people call it the C10 work permit based on the LMIA exemption code. There's no LMIA recruitment for this type of work permit, but the reality is that it is a very broad discretionary assessment by officers when they're assessing the application. That doesn't mean that it's a flexible workaround. So C10 work permits are not a backup plan. It's a different legal test entirely. It falls under the International Mobility Program. So it allows the work permit to be issued without an LMIA if the applicant and the employer can demonstrate that their work will bring economic, social, or cultural benefit to Canada. The key here is that the benefit has to go beyond the employer and beyond the company. It must impact a broader community, region, or a sector. So effectively, the benefit has to impact Canada as a whole. Now, in February 2026, IRCC updated its guidance and raised this bar significantly. It is now reserved for unique or exceptional situations. It requires demonstrable, measurable impact, and it has to show benefit that extends beyond this employer and the applicant, and certainly beyond the operation as a whole. So officers are now explicitly instructed to weigh the benefit against labor market risks. Consider whether Canadians could be displaced by the employer hiring a foreign worker. Assess whether the applicant is truly necessary in Canada. So a strong C10 application today has to answer three core questions. Why this person? What makes this foreign worker unique? Don't just discuss their qualifications and their experience in your submission. You have to demonstrate that the foreign worker is exceptional. And documentary evidence from IRCC suggests that you include things like the foreign worker's national or international awards or patents, their membership or of an organization requiring excellence of its members, a member of a peer review panel, or an authority to judge the work of others, that they're recognized for their achievements and significant contributions to their field by their peers, by government organizations or professional or business associations, their previous scientific or scholarly contributions to their field, that they have publications in academic or industry publications, or just in general in newspaper articles, that they're currently or they've been a leader in an organization with a distinguished reputation, that they're renowned for their artistic and cultural endeavors. So any of this above would indicate that this person's presence in the Canadian company is going to be a significant impact. It shouldn't just include their educational credentials or their employment experience letters either. Now, the scale of significance can be addressed in the context of the company's operations. Where is this company located, and how significant is its success to the local economy and their sector? If possible, quantify that with dollar figures. How will the foreign worker expand or advance the industry? Are there technological developments that relies on the foreign workers' experience or expertise or their knowledge? How can the foreign worker contribute to jobs creation or skills transfer and training? Other economic benefits that you should discuss include business transactions that would improve Canada's competitiveness globally, market expansion, and product or service innovation, economic growth through employment opportunities. So address unemployment rates, for example, and how would the foreign workers present in Canada address that? New goods or services that could become available, which is currently unavailable to Canadians, especially in the pharmaceutical industry or the technological industry. Economic stimulus in remote areas where the employer may have operations or plans for operations. IRCC will also consider social benefits like quality of life and standard of living improvements in Canada in rural areas, environmental conditions through sustainable operations, and truth and reconciliation efforts with local Indigenous communities where the foreign worker and the employer can contribute. None of these should be potential benefits, so they need to be credible and they need to be supported by evidence. Where do most applications fail? I would say, firstly, that many practitioners rely too much on job descriptions and knock codes, and not enough on the actual impact or the benefits themselves. So it isn't that these work permits are reserved for senior management or executive management. They just have to be able to demonstrate that there are going to be impactful or significant benefits. Or they're framing benefits as only to the employer and the company, generating revenue for the company or generating revenue for the employer or creating jobs for the company's employees. And they fail to address the benefits to the community or the country as a whole. Submitting generic requests with no market research or supporting evidence is also going to lead to a refusal of the application. Failing to prove the necessity of the position in Canada. C10 is not a workaround or a shortcut. There's a very high threshold of discretion. So this person needs to come to Canada to create something that we wouldn't otherwise have in this country. If you are successful, your client could be issued a work permit for up to 3 years, which could allow them to remain in Canada and wait for permanent residence opportunities through express entry or the BCPNP or new pathways that may be introduced by IRCC. Rosalie?
Well, a very helpful strategy for practitioners and their clients. Thank you for walking us through that today, Tiffany.
You're welcome.
Let's talk again.